increasing number of cross-border problems in this area. Some problems can't be solved by a regional or national level. And what if subsidiarity doesn't work really? Well, then we go in, we have two different options. One is that we act as the guardian of the treaty, and we do apply community legislation directly, which means that we take member states kicking and screaming to court. The other alternative, the first option is good if you have a rather isolated problem, that you take one member state to court. If you have just a fragmented regulatory environment with a lot of different regulations, then it could be worthwhile looking at harmonization of an issue. It was touched on harmonization here previously as well. Most commonly, it's correct that we do not have any specific legislation relating to gambling, but we do have a lot of community law, secondary legislation, who covers gambling. We have, from 1984, we have the directive on misleading advertising and comparative advertising. There is no exclusion for gambling. Gambling is covered by this directive. We have the Television Without Frontiers from 1997, which also covers gambling services. If somebody advertised a gambling service on television, it was completely covered by the directive. We have the Transparency Directive, or the so-called Notification Directive, which means that if any member state would adopt legislation that is specific for information society services, it must be notified to the European Commission and the other member states during a specific procedure. If it's not notified to the Commission, which we see now in the neighboring country here, Portugal, you can't apply the legislation. You can't enforce legislation that is not notified against companies or citizens. So it's it has some teeth. We have a money laundering directive which covers gambling. It has been revised. Now we are on the third money laundering directive that covers specifically casinos and casino activities. It also covers online casinos and not only the physical casino. We have the unfair commercial practices, which basically replaced the misleading and comparative advertising directive as regards business to consumer activities. Here it was discussions about making a derogation and taking out gambling services. It didn't happen really. It's still there. I don't know what really happened, but that covers gambling services. The whole idea with the Unfair Commercial Practices Directive was to extend misleading advertising to misleading omissions and also aggressive practices. And that covers gambling. As mentioned before, we have directives that excludes gambling. We have the e-commerce directive. I worked with that one, and we sat with that in '98. We thought that nobody would use this credit card to go on gambling site. It was a quite heavy political pressure to adopt this rapidly. We throw online gambling overboard quite soon in the discussions there. We have the Services Directive, who excludes gambling. The interesting thing is that during the debate it was a lot of confusion what actually happened with gambling services when it was in the directive, and you got actually bookmakers lobbying against their own interest and member states lobbying against their own interest. Now we hear from a lot of parties, especially from member states who seek to protect the national market, that it was a great shame that it didn't remain in the Services Directive. The third directive, which excludes gambling services, is the Audiovisual Services Directive that was recently adopted. Here it's not really sure whether or not gambling services are excluded from the scope or not, because the exclusion, I don't know the quote of lawyers in the room here, but a derogation in a European directive must be in the body of the text. It cannot be legal provisions in recitals or the preambles of a directive without a corresponding provision in the body of the text. In this directive, we do have it in recital. We do not have any derogation for gambling services in the body of the text. What is the problem with harmonization from our point of view then? Well, first we have to make a decision if we should do minimum harmonization or full harmonization. Member states normally prefer a minimum level, and they can go over that to impose more strict or more liberal regulation if they want to, particularly more strict. The problem from the internal market perspective is that it remains a fragmentation. If you just have a minimum level, and then member states find a different way of going further, we still do have a problem with cross-border services. We also have the idea with derogations. I mean, we heard that we have a derogation for gambling services in the e-commerce directive. We have it in the services directive. The only thing that happens if you have a derogation from secondary legislation is that you move it back into the primary legislation. That means the treaty. And we come back as the guardian of the treaty, and we enforce community legislation. You still have the internal market principles. So sometimes, if you want to have a real derogation, if you would like to ring-fence an area, let it be in the secondary legislation and deal with the issue there. Direct application of the treaty, sometimes referred to as infringements. The Commission acts on complaints here. We have too much work in this area to start looking for trouble. We only act on complaints that we get, mainly from citizens, from bookmakers, from media, and from others. But that is the main group who submit complaints to us. Today we have procedures against 10 member states. They are listed there. I will not read them to it. It focuses on sports betting services and its provision and promotion, cross-border provision and cross-border promotion of sports betting services. The first case was opened in 2004, so we have been working with this for 5 years now without referring a single member state to court. But it was a 2-year pause there from 2004 to 2006 where we had a change of commission where we didn't really know what direction we were heading for. So any suggestion that is the current Commissioner Charlie McCreevy who started this, it's not correct. It was the previous Commissioner who started to look at gambling. 5 of these cases, Denmark, Greece, France, Netherlands and Sweden, there we have come so far, so we now have to decide within the Commission whether or not to refer these member states to court or not. The other way that we have some regulatory action in this field is by the Court of Justice. Member states' courts, national courts, if they're uncertain about how to interpret the treaty, they can refer questions and issues to the Court of Justice. Today we have 14 cases pending in the Court of Justice relating to gambling services, where we are waiting for different kind of rulings. They are listed here. Portugal, Austria, Germany, a lot of cases in Germany, given the regional nature with this German lender. You have a lot of different legislation there for the volume there. We have 2 cases against Holland and we have 2 cases against Sweden. What's happening now? I said in the beginning we have things going on both in the Council of Ministers and the European Parliament. In the Council, the French presidency had discussed the issue of gambling during a couple of meetings. It was an exchange of view on the 1st of December where member states put their positions on the table. At this meeting, it was clear that member states do not want the Commission to harmonize, at least not now, in this field. Member states, particularly those who is subject, the 10 that is subject to an infringement procedure, thought it was worthwhile continuing the discussion in the Council. Could we find a common platform? Could we have an exchange between member states of best practices, etc.? The Czech presidency has taken over now is likely to have 1 meeting on this issue. It is also likely to be a rather informal meeting. The Swedish presidency that will come after a summer will have most likely a little bit more ambitious program to look at gambling issues. They're talking about 3 to 4 meetings. Even if the vast majority don't want to see the Commission proposing any harmonization, they would like to see a little bit more active Commission in this field. It was referenced to the Commission should do studies and surveys, and especially in relation to gambling addiction and problems related to crime. The European Parliament previously was mentioned EP report on integrity on online gambling that is drafted by a Danish member of Parliament. The Internal Market Committee will discuss a large number of amendments on the 11th of February. They are now meeting next week to try to merge a lot of amendments. So I think when we come to the vote, it will be less than 100 amendments. The Parliament will in plenary vote on this report in March. And the Parliament, I should be conscious about time here now, is basically echoing what was said by the Council, with the difference that the Parliament, they have not adopted a position yet, but they have floated the idea of having a code of conduct in this area that would be backed up not by community legislation necessary, but national legislation. But some kind of code of conduct they would like to see there. Then you have the request for studies and surveys that is echoed from what we heard in the European Council. That is not likely to happen very soon because we have a budget to play with. So if we would decide to do something today, it's not sure that we could do it before the start of 2010. To round it off now with future actions here, whether or not anything will be referred to the Court of Justice during this year, it's not really sure. It's always up to the member states to modify the legislation that we have started looking at. If they modify the legislation, well, that would be actually the best thing and the most rapid solution. But then the question will be again if that is compatible with EC law or not, or if we have to restart the procedure. I think during the year, or I'm sure that during the year, we will have judgments, guiding judgments from the Court of Justice. How will the Commission respond to the Council and the European Parliament on the position mentioned here before? The Commission will not propose harmonisation, not the sitting Commission at least. What the next Commission will do, that is completely up to them. Will we do studies? Well, if we are under very heavy pressure to do a study, we will try to revise the existing budget and see if something can be done, but most likely no studies will be launched. And if we would launch a study today, we will have a call for tender. It's a quite slow procedure, so we would not see anything coming out from the Commission if we decide now to launch a study at the earliest, end of 2010, beginning of 2011. So I think I almost kept me to 15 minutes there. So thank you very much for your attention.
Muy bien. Thank you, Bertil. Muchas gracias. Seguimos entonces con el programa previsto y a continuación tenemos la intervención del señor Phillips. Recuerdo, vocal del Comité de Prácticas Publicitarias del Reino Unido, órgano de reciente creación y que ha ido avanzando precisamente en uno de los asuntos que es el de la publicidad de debate en muchos otros países europeos. Muchas gracias, Malcolm. It's your turn.
Gracias a la Fundación Codere por haberme invitado a hablar sobre la experiencia inglesa en la regulación del sector publicitario en el ámbito de los juegos de azar. Lamento decir que haré el resto de mi presentación en inglés, ya que hablo poco español. Un amigo mío tradujo esta introducción. First of all, I should introduce the organisation for which I work. The Committee of Advertising Practice is a self-regulatory body that was established in 1961. CAP writes and enforces the British Code of Advertising, Sales Promotion and Direct Marketing, the CAP Code. and the CAP code covers non-broadcast advertising. For example, newspapers, magazines, posters, and cinema advertising. It also covers some advertising on the web, third-party advertising, but not marketers' own websites. The CAP code is enforced against advertisers, and it is not voluntary. Unlike some systems in other European countries, it's not membership-based. It is enforced against all advertising. The Committee of Advertising Practice has a central committee which decides on changes to the rules, and that committee is comprised of trade associations for advertisers, media owners, and advertising agencies. The Broadcast Committee of Advertising Practice is the self-regulatory body that writes and maintains the codes for advertising on radio and television. BCAP was established in 2004, and it operates a co-regulatory relationship with Ofcom, which is the government regulator for broadcasting. BCAP, the Broadcast Committee, is obliged to seek advice of a consumer body, the Advertising Advisory Committee. BCAP must also consult publicly on any changes to the rules for television and radio, and it must seek Ofcom and government's final approval for rule changes. The BCAP codes are enforced against broadcasters licensed by Ofcom. And like CAP, BCAP is comprised of media owners, broadcasters, and trade associations for advertisers and agencies. First, I'd like to explain the situation of gambling advertising in the UK before September 2007. Before September 2007, gambling advertising was regulated by a number of different laws, supplemented by guidance from the Government Department for Culture, Media and Sport, DCMS, and the Gambling Commission. The laws had the intent of ensuring that demand for gambling could not be stimulated. Advertisements for gaming could inform the public, but could not offer incentives by offering bonuses or free games and so on. However, advertisements for betting could do that. There are some provisions from the CAP code from before September 2007 for gambling. I won't go into detail on those, but I would draw your attention to the fact that licensed casinos, physical casinos, could only advertise in classified advertisements and could provide only factual information before 2007. The discrepancy was that offshore remote gaming could do a lot of things that casinos could not, because the legislation for gaming did not foresee the advent of the internet. And this is a situation I know is common to Spain as well. In broadcast, before September 2007, advertisements for betting and gaming were simply not permitted. There were exceptions for TV text services, and advertisements for lotteries, football pools, and bingo. But betting and gaming could not be advertised on TV or radio. Moving on, after September 2007, well, the Gambling Act was passed in 2005, It replaced all existing gambling law, and it gave new scope for betting, casinos, and lotteries to advertise, particularly on television. There was a new legal definition of advertising, which is very broad and is intended to capture remote gambling by mobile phone or by internet, non-remote gambling, and also marketing arrangements, sponsorship, and so forth. The Gambling Act introduces new restrictions on who can advertise in the UK. Gambling firms based in the UK can advertise, and also advertisers based in the European Economic Area. And also advertisers based in countries that are listed in something called the White List by the Department for Culture, Media and Sport. This is a list that is operated to assess countries to see whether their regulatory framework meets the minimum required level for the British government to permit them to advertise their services in the UK. At the moment, I believe Alderney, Antigua, Barbuda, the Isle of Man, and Tasmania are all on the white list. Responsibility for gambling advertising falls between the Gambling Commission, the Department for Culture, Media and Sport, and Ofcom. The Gambling Commission is responsible for non-broadcast advertising, Ofcom for broadcast advertising. Under the agreement between Ofcom and BCAP, Ofcom invited BCAP to draw up the rules for gambling advertising for those sectors that could now advertise on television and radio. The Gambling Commission then invited CAP to do the same for non-broadcast. This ensures that the rules are consistent across all media, and it maintains the integrity of the self-regulatory system in Britain for advertising. CAP and BCAP did a full public consultation during 3 months in 2006, and then published their new rules in March 2007. Those rules came into force with the Gambling Act on the 1st of September 2007. The objectives, the policy objectives, in considering the new rules were to allow gambling to be advertised as a responsible leisure or entertainment activity, and to ensure that reduction of harm should take precedence over the maximisation of innovation, consumer choice, and economic gain. The core gambling objectives are the 3 listed here. The third is the most relevant, I think, to advertising, which is to ensure that children and other vulnerable persons are protected from being harmed or exploited by gambling. BCAP, because of its co-regulatory relationship, also had to observe standard objectives under the Communications Act, which were that the public should be protected from misleading, offensive and harmful material, and that under 18s should be protected. The general principles of the new gambling advertising rules are that advertisements should not portray, condone, or encourage gambling behaviour that is socially irresponsible or could lead to financial, social, or emotional harm, and that advertisements must not exploit the susceptibilities, aspirations, credulity, inexperience, or lack of knowledge of children, young persons, or other vulnerable persons. These are some examples of the rules that deal with the social responsibility of gambling advertising. These rules are intended to stop advertisers encouraging excessive gambling. Gambling advertisements, for example, should not suggest peer pressure to gamble or disparage abstention. The other objective, the protection of children, is dealt with in two main ways. First of all, through rules on the content of advertisements. So no one under 18 may appear in a gambling ad, for example. The second way in which the rules seek to protect children are by restricting the placement or scheduling of advertisements. No advertisement should be scheduled or placed in or around media directed at under 18s. There are some exceptions for lottery advertisements which may be directed at which may be scheduled or placed in and around media directed at 16, 17-year-olds. But lottery advertisements may not appear around media directed at under 16s. The Gambling Act also refers to other vulnerable persons. The Gambling Act does not define vulnerable persons, but the Gambling Commission assumes that this category includes people who gamble more than they want to, people who gamble beyond their means, and people who may not be able to make informed or balanced decisions about gambling because of mental impairment, alcohol, or drugs. To tackle this objective, the rules include provisions that state advertisements must not suggest that gambling can provide an escape from personal, professional, or educational problems. They must not suggest that gambling can be a solution to financial concerns, and they must not suggest that gambling can enhance personal qualities. The Gambling Commission also requires the gambling industry to draw up its own code of practice, its own code for best practice, which will cover not only advertising, but marketing in betting shops and the conduct of staff at casinos and so forth. The Gambling Industry Code for Socially Responsible Advertising is part of that code